Did you get a chance to listen in to the Seventh Circuit U.S. Court of Appeals yesterday in the challenge of Illinois' gun and magazine ban? We'll unpack it here with Illinois in Focus Daily. Wake up with us each and every weekday morning here for the Center Square. I'm Greg Bishop, editor of Illinois at the Center Square, free newswire service where you can get headlines in your inbox each and every weekday morning. You can also check out the podcast here with the Center Square. Just go to thecentersquare.com and donate as well. It's a nonprofit newswire service. Donations definitely help us in our mission to keep you updated on what's going on in Illinois and around the country, in Washington, D.C. and beyond. The latest out of Illinois, you'll see an investigation about the fiscal fallout of the state's spending 43% more under Governor J.B. Pritzker than before. So we'll have to talk about that story in some detail later on throughout this week, because some of the line items are pretty incredible when you look at them on a chart and you see just the percentage increase of these line items. So we'll have to tackle that eventually. But we're going to do two segments today. One, reviewing the Seventh Circuit U.S. Court of Appeals, some of the highlights from oral arguments yesterday. But then we're going to connect with Todd Vandermeide, gun rights advocate. He's the president of Aurora Sportsman's Club. He's a former NRA lobbyist at the State House, regularly testifies in front of committees at the legislature. So we'll talk with him to get his reaction on what he heard during... All right, hopefully we don't have any buffering issues. Just want to, again, remind people we do this live to tape when we go live on YouTube, but I also record the segments locally. So if for some reason the segments during the live stream are chopped up, we'll have the entirety of the segments available at YouTube or on the podcast in its entirety. Again, just search Illinois in Focus Daily.
I really worry about the blah, 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 et cetera, given that the district court didn't make findings on several of the things we told it needed to.
The 4-day trial, 16 to 18 expert witnesses, 250 exhibits. I think this is the first time we've had a full trial record. Any federal appellate court in the country has had a full trial record. Isn't that an uphill battle for the state to overcome those findings?
The United States' position is that AR15s and similar weapons are clearly arms that are protected by the Second Amendment. They are not militaristic. Militaristic analysis is not even a correct rule to apply. It is not found in Supreme Court precedent. It is not appropriate historically, and it is not appropriate in the context of today. And so for these reasons, we believe that it's the incorrect test to apply.
That is just some of the highlights from yesterday's oral arguments in the Seventh Circuit U.S. Court of Appeals challenging Illinois' gun and magazine ban. Welcome in to Illinois in Focus Daily. I'm Greg Bishop, editor of the Center Square, Illinois. Go to the Illinois page and find the latest headlines, including just one story of yesterday's oral arguments. There's going to be plenty that comes after, including continued analysis. So let's, this segment, focus on what was heard in the court yesterday. And how we got to this point, right? So we're at the merits of the issue in the appeals court. The next step could be the U.S. Supreme Court to deal with the question of whether a government can ban or whether a state can ban semi-automatic firearms that plaintiffs say are commonly owned firearms for lawful purposes. So back in 2023, Governor J.B. Pritzker enacted the Protect Illinois Communities Act. It prohibited the sale of and possession of more than 170 semi-automatic firearms, pistols, shotguns, rifles, all kinds of attachments being banned, magazines over certain capacities for shotguns, rifles, handguns being banned, criminal penalties being associated with possession of those if they're not registered with the state, and there was a deadline to register those with the state after the law became effective. So it's been in effect since January 2023, only 6 days where it was not in effect, and that was on preliminary grounds in the district federal court where Judge Stephen McGlynn, on the initial request to temporarily block the law from being not enacted but enforced, there was that 6-day window on preliminary grounds. That was back in 2023, I think like April or so. And then that went all the way up to the appeals court. The appeals court reversed that 6-day window, and then it even went up to the U.S. Supreme Court on preliminary grounds. And those preliminary grounds, the U.S. Supreme Court said, no, we're not going to take the case. It's not ripe yet. So went back to the district court in 2024, where they debated the case on the merits with a 4-day bench trial, with thousands of pages of records, testimony from all kinds of different experts on both sides of the equation here. And then the federal district judge last year ruled the law was unconstitutional. Now, he put a stay on his own order. A stay is essentially saying it's not going to prohibit the law from being enforced yet until the appeals court deals with it. Then the appeals court got the case from the state because the state was found to be enforcing an unconstitutional law by the district court. And then it gets to the appeals court. The appeals court keeps the district court stay on. So the law is still in effect, even though the district court said it's unconstitutional. So now we had the appeals court hearing yesterday. So let's get right into it. You have the states defending the law, saying that M16s and AR15s are very similar, but you've got a 3-judge panel here. And we're going to hear voices from Judge Michael Brennan, Judge Frank Easterbrook, and Judge St. Eves. And as we talked with Dan Eldridge yesterday, all eyes on Amy, he said, because St. Eve is a new judge on this 3-judge panel. Diane Wood used to be the 3rd judge on this 3-judge panel, but she retired, so they replaced her with Amy St. Eve. So that's the 3rd voice you're going to hear. Let's get to the highlights.
It remains undisputed that when fired in semi-automatic mode, the M16 and the AR-15 have identical capabilities and lethality. It's also undisputed that the military typically uses M16s in that semi-automatic mode.
What about Ms. Hunger, the argument that one of the state's expert witnesses talked about the fact that they would never send semi-automatic firearms into battle, yet automatic capability is important?
The state does not dispute that the automatic capabilities can be used in certain circumstances, such as suppression fire, and also that that can have a utility. It's also important to note, however, that all of the experts, including the plaintiff's experts, agreed that that was rarely used, that automatic capability. And part of the reason is because when troops are sent into battle, they typically also have an individual that has an M249, which provides suppression fire. And so typically individuals that have the M16 are using semi-automatic fire, and it's only in kind of unexpected or rare circumstances that they would use that for automatic fire, but that is a capability that is used. Yes.
So the argument, went back and forth with some questions from Judge Brennan. You had other judges asking questions from the 3-judge panel, but Brennan said that it seems to be an uphill battle for the state to defend the law, given the large record that was created in the district court.
Isn't it an uphill battle, though, for the state? Here we've got a clearly erroneous standard of review. We've got a district court who held a 4-day trial, 16 to 18 expert witnesses, 250 exhibits. I think this is the first time we've had a full trial record. Any federal appellate court in the country has had a full trial record. Isn't that an uphill battle for the state to overcome those findings, like M16 is different than AR-15?
No, Your Honor, for 2 reasons. The first is because de novo review applies here, and I'm happy to get into that. But also, I'm happy to address any statement under a clearly erroneous standard that the district court made and show why we believe that we can overcome it, either because it's actually undisputed or because it's disputed but not.
Doesn't require a particular format. So the district court did make specific findings differentiating AR-15s from M16s and M4s. And how do you get around that?
And these are really interesting questions that the judges are asking of the state, including Judge Amy St. Eve asking those targeted questions towards the state, and the state having to, formulate responses to those. But the states talked about self-defense, and in particular, the issue of, what exactly is self-defense.
So we have empirical evidence in the record showing that these weapons are not necessary for self-defense. They're not chosen by individuals for self-defense. They're not even the most useful for individuals in self-defense. And on the other side,
is the Lucy Allen report focused on Illinois, or is it broader?
it's broader.
And would your statement that you said earlier about not using AR-15s for outside of the home because of gun regulations here, would that impact the Lucy Allen report at all? So could her statistics be off if her focus was not based on Illinois and the concealed carry, etc.?
No, I don't think so. I mean, in this kind of universe, to be perfectly honest, is we have just different types of data available for these things, and Lucy Allen looked for the type of data that she could get, and that's what she could find. In other states, there are state-specific databases. I'm not aware of any in Illinois, and so I think her scope was national.
And again, this is evidence that the state was providing, talking about the types of firearms that are used in self-defense more often than not, and it's typically handguns. And it seemed to be a way to try to balance of sorts. The state's trying to say what kinds of firearms people can use to protect themselves. But then Brennan asked about what kinds of historical analogs there are to say that there were firearms prohibitions during the founding era. Again, a precedent that was set by the U.S. Supreme Court.
Lewin tells us that we're to look to the how and the why of the law to determine its analogousness.
Yes.
That one weapon ban that you're talking about, how does that satisfy the how? Or how does that satisfy the why?
So it was a ban on possession of trap guns in 1771 in New Jersey. That was the example that I was thinking of. And then, let's see here, there were 8 more of those bans in the 1800s and 9 in the early 1900s, and then there were bans on Bowie knives all throughout the 19th century, then semi-automatic and automatic weapons.
And we're to look to the how and the why of the
Yes.
ban. That's where there's trouble for the state on that second step, isn't there?
No, there isn't, as this court held in Bevis. I mean, I think to reach that conclusion would require reaching a different result than the one that this court reached in Bevis. And because the historical tradition is about reserving, dangerous weapons for law enforcement and military use and restricting civilian access to these especially dangerous weapons in a manner that is appropriate for the danger that they pose. And so these, weapons, trap guns, of course that's why you would ban the possession, because you don't want a trap gun at your house.
So the trap gun issue, something that we're going to flash forward from the states, because how they set this up is the state gets 45 minutes and the plaintiffs get 45 minutes. So we're still in the state defending the case that was found unconstitutional by the district judge. But I'm just going to flash forward because, she brought up this trap gun ban back in the 1770s, and Thomas Magg, who was representing the Langley plaintiffs challenging the gun ban, he got a 5-minute chance to talk about some things, and he specifically talked about that particular issue.
But what was discussed earlier in the debate, some of the questions back and forth, was questions whether there were historical bans on types of firearms, and a trap gun was brought up. And I think trap, to a lot of people in the shooting sports today, probably refers to shooting clay birds. Well, that's not what they banned. A trap gun is a booby trap. It's something designed to be set in an unoccupied structure to kill burglars and trespassers. Well, I mean, human lives are far more valuable than property, and so many states probably justifiably banned the setting of trap guns, spraying guns, booby traps, as they should have. And in the course, I mean, there is no legitimate function, no self-defense function, no military function, no sporting function for a booby trap. So, I mean, that's what that had to do with.
So again, Mag had his opportunity in front of the appeals court. Just wanted to kind of flash forward to that. But back to the states arguing for the gun ban. Judge Eve was talking with the state attorney representing the state and said, listen, the Beavis situation is at play here, and it may not mesh with the U.S. Supreme Court precedent.
I think the first Beavis was shortly on the heels of Bruin, and we were one of the first courts to tackle the challenges of Bruin. There has been additional case law that has come out, including Rahimi.
Yes.
What is the state's position as you're here today on how we should construe dangerous and unusual? Is it dangerous and unusual, dangerous or unusual, unusually dangerous? The courts that have addressed it are a little bit all over the place.
You know, a little bit, but I was actually reviewing the decisions for that issue a couple of days ago, and in addition to Beavis, the Lamont, the Bianchi, and the Hansen decisions have kind of centered around this particularly dangerous, especially dangerous terminology that was used by this court. So that would be, I think, 4 out of the 5 or 6 circuits that have addressed this. So even though they use different terminology, perhaps some's especially dangerous, some's particularly dangerous, it actually was a lot more coalesced than I perhaps expected to find when I set out to read them.
Now, the plaintiffs do argue that, the dangerous element is, focused on firearms or weapons that are indiscriminate. Things like grenades or, chemical weapons and the such. So, just kind of countering here what you're hearing from the state defending the law and the questions that the judges are asking. Brennan asked the state about the unprecedented societal concerns over mass shootings.
I think that although there were certainly mass murders, and this is also in the record, there were mass murders, but there were not mass shootings. And if you look at the act that is at issue here, it is designed to address mass shootings, and that is a new societal concern. It is not attempting to address homicides or mass murders more generally, and it does not say that it is attempting to do that, because it's not regulating other types of actions that could lead to mass murders. It is regulating the weapons that are used in mass shootings, and that is a change, and also the technology has changed.
I'm losing you where the change happens, because there have been mass shootings as that's defined going.
And we don't dispute that there were some mass shootings 30 years ago, but there are a lot more mass shootings that are happening now. And, as Justice Barrett indicated in her concurrence, legislatures do not lose the ability to regulate simply because they did not do it at the earliest possible moment.
So again, you've got the ongoing debate between the judges and the state as to how they can justify the state's ability to ban what the plaintiffs call commonly owned firearms. All right, so that's just an encapsulation of the state's arguments. Now we have some time here left before we jump over to the next segment with Todd Vandermeide, but I wanted to share with you what the plaintiffs were saying. Aaron Murphy is talking about the differences between AR15s and M16s, and says that the record in the district court really spells that out.
And what it explained is, from the court's perspective, after understanding all the record evidence, that really what puts something on the military side of the line is automatic fire. And that automatic fire is different because it serves a suppression need, and that's why, and that the military has. The military may need to pin troops in place, keep people from advancing as you're trying to enter a structure to clear it, where you don't pin troops in place, keep people from advancing as you're trying to enter to clear it, where you don't know who your target is, and you don't care if you're firing as accurately, you just want to fire quickly. That's like the opposite of what Illinois is coming at here, because as the court explained it, I don't think Illinois disagrees about this. It's singling out features here because they make firearms more accurate. They make it easier for someone to stay on target. So it's singling out the very thing that drives an even bigger wedge between an automatic firearm that is military grade and a semi-automatic only firearm that I don't think there's any dispute is not something that has ever been a service issue combat rifle in our military or any other military in the world. And what the district court said is once the court looked at things like rate of fire and control, that's the big differentiator, and that in the self-defense context, you just don't have that same need for suppression fire that you might in the military context, because as this whole case is about showing, people want firearms in the self-defense context that are more accurate.
So Erin Murphy, representing the plaintiffs in this case, laying out her case. Judge Easterbrook, Frank Easterbrook, he jumped in and interrupted.
I really worry about the blah, 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 et cetera, given that the district court didn't make findings on several of the things we told it needed to.
He went on to complain about the district court not looking at the rate of fire as an issue that needs to be addressed, or the capacity of magazine issue that needs to be addressed. But back to the crux of the argument, more from Erin Murphy.
So I think that, as I understand what the Supreme Court is saying about our historical tradition, it is one under as between the people and the government choosing which weapons are best suited for the people's self-defense, we defer to the views of the people. Now, in some instances, that's easy to do because you can look at some things, and we would submit this case as one where it is easy to do because even by the state's experts' estimation, 14 to 18 million individuals own AR-15 style rifles, and many, many more own the magazines that are banned here. And there's simply no real dispute that they own them for the purpose of self-defense. They'll dispute whether they think they need them. But if you're just asking that, we think this is an easy case. I mean, I think, the answer most consistent with the Second Amendment is you don't jump in and try to ban things until you actually really think there's a problem with them. And if something's coming on the market that seems like it just makes firearms do what they're supposed to do better, i.e. be more accurate, easier to use, maybe a little faster, but faster in a way that doesn't sacrifice accuracy, it's pretty odd for the state to say, we want to jump in and say, no, you have to stick with outmoded technology. If you have something that comes on the market that's meaningfully different, say in a way that, I think when you look at the things historically that people have been happy to see banned, one commonality you see among them is an indiscriminate nature. Grenades, chemical weapons, the idea of handheld nuclear weapons.
So again, that's Erin Murphy representing the plaintiffs. Judge St. Eve asked questions of Murphy.
How do we think about that a lot of the mass shootings, especially those that have included a large number of victims, these weapons were used for illegal purposes? You said 14 to 18 million legally own them for legal purposes, self-defense, but there are also these statistics on the other side. Does that factor in with the nuanced approach or the societal concerns? What are we supposed to do with that?
I mean, the answer is I don't think what you can do with that is say that's a reason that they're wholly unprotected by the Second Amendment, because that's an argument that says, okay, we're going to focus instead on...
But that would be on the arms question.
Well, I think on either question, because, I just don't think there's a tradition in this country of saying that particular weapons, because if somebody, who is going to misuse them got their hands on them, they would be very dangerous. I mean, every weapon is incredibly dangerous in the hands of someone who wants to misuse. And I would note that the state's own expert on this said that it's about 20% of mass shootings that a Illinois-defined assault weapon is used in, and less than half that an Illinois-defined large capacity magazine is used in. So,
but I thought the expert also said once you start getting into higher numbers of deaths, that those numbers go up.
And I think that's part of why this, I don't think, with all due respect to my friend on the other side, that there's a kind of generally accepted easy way to conceptualize what is and isn't a mass shooting.
The nuance, the legalities, the questions. This is how these things go when they are debating these and in oral arguments. Doesn't matter what the attorney has in front of them as their script to make their arguments. Judges are going to interrupt. They're going to jump in with their questions. They have a limited amount of time, so they're going to ask those questions. So the plaintiffs split up their 45 minutes. Erin Murphy had time, the most of it. Thomas Magg had time. We heard a little bit from him. But the U.S. Department of Justice was there. Harmeet Dillon, the Assistant Attorney General for the United States Department of Justice in the Civil Rights Division, there to argue on behalf of the plaintiffs suing the state over the gun ban. And Dillon started off their argument.
Assistant Attorney General Harmeet Dillon for the United States. as amicus in support of plaintiffs' appellees and supporting affirmance of the district court's opinion. The United States has a strong interest in ensuring that the Second Amendment is not relegated to a second-class right, and that all the law-abiding citizens of this circuit remain able to enjoy the full exercise of their Second Amendment rights as binding Supreme Court precedent requires. The law at issue, a so-called assault weapons ban...
Let me ask you about the standard of review again.
And that is Judge Easterbrook jumping in with a question to Dylan.
Suppose the district court had found every contested issue of fact in favor of the state. Would that affect your view of the statute's constitutionality?
It would not, Your Honor. And
So you don't think the facts matter?
the facts would
Right.
matter, but
What matters to me is that we know we have 4 essentially identical cases pending before district judges in this circuit. And one thing that worries me is what happens if they don't agree with each other. But you suggest that that's not going to matter.
if I may, Your Honor, I did not get the chance to complete my argument, which is that we believe the standard at this court's level was inaccurate. We do not support the militaristic formulation. And so the district court went to some great lengths to harmonize Heller and Bruin with this court's opinion. But it's the position of the United States that the Bevis standard is at odds with the Supreme Court standard. And so had there been some different factual findings under the rules set by this court, it wouldn't affect my opinion as to the constitutionality of the statute.
Just a couple of more clips here before we get to Todd Vandermeiden in the next segment. The Department of Justice making their case with Harmy Dillon there. Judge St. Eve asking questions of Dillon.
And is it your position that it's because Bevis requires these factual findings, whereas the test that you would propose does not?
No, Your Honor. The factual findings would have to be made in any case. And so I don't mean to imply that one could reach a conclusion on the constitutionality without engaging the analysis as to whether this particular law meets the two-part analysis of both having met the historical tradition of dangerous and unusual. We accept that standard. But the question of what is an arm in the first part of the test is affected by this court's ruling in Bevis. And I think that is where we would disagree at the United States level, because I think the trend in the Supreme Court is very clear, as Judge Easterbrook indicated. It is, the clues are there that the Supreme Court, in just the justices who have addressed this issue, particularly Justice Thomas in his dissent from Cert and Snope, has indicated that with 41 states accepting AR-15s as arms that are legal for Americans to possess for legitimate purposes, they are presumptively legal. And then the legislature has to come up with the justification under the historical dangerous and unusual test. And I think the district court in this case did a good job harmonizing Bevis with Heller and Bruin and reaching its own determination of historical and dangerous. We accept those determinations for purposes of this appeal.
And again, this is Harmy Dillon, the Assistant U.S. Attorney General, there at the Seventh Circuit U.S. Court of Appeals, closing out her arguments before the judges took the case under advisement.
The United States' position is that AR-15s and similar weapons are clearly arms that are protected by the Second Amendment. They are not militaristic. The militaristic analysis is not even a correct rule to apply. It is not found in Supreme Court precedent. It is not appropriate historically, and it is not appropriate in the context of today. And so for these reasons, we believe that it's the incorrect test to apply.
So there you got the case in the hands of 3 justices of the appeals courts. What exactly do we take away from this? It's a great question. We'll get some analysis here with Illinois in Focus Daily. I'm Greg Bishop, waking you up each and every weekday morning. Hit subscribe, like this video, share it up. We do this each and every weekday morning here for the Center Square. So go to thecentersquare.com and sign up for the headlines in your inbox each and every weekday morning. Again, thecentersquare.com. All right, right, guys, stand by. Todd has been patiently waiting. I told him 8:15, and here we are. It's 8:30. So, wow, I appreciate his time. Todd, we're not recording the segment yet, but we are live. Just want to make sure I've got you coming through my audio system here. So go ahead and give me a mic check.
1, 2, 3, 4.
All right, we got that mic check. Stand by. We'll go with the segment here in a moment. Now that the Seventh Circuit U.S. Court of Appeals has the case of the challenging of Illinois' gun and magazine ban in their hands, they took it under advisement after hearing it yesterday for 90 minutes. What does it mean? What does all this spell for what we could anticipate seeing come forward from the Seventh Circuit U.S. Court of Appeals? This is Illinois in Focus Daily. I'm Greg Bishop with you each and every weekday morning. Let's connect now with Todd Vandermeide. He is president of the Aurora Sportsman's Club, a former gun rights lobbyist at the state capitol, also somebody who advocates for gun rights at the state capitol still to this day, showing up at legislative hearings and such, and I appreciate him taking the time this morning. Tell us what you heard, what you saw yesterday in the Seventh Circuit Court of Appeals, Todd. Thanks for joining us. Oh, hold on a second. I apologize. I even checked the microphone before we went live, and I didn't turn your mic back on. Go ahead.
That's fine, Greg. Great to be here. So we prepped for what we thought was going to be a bare knuckles brawl like when we were there 2 years ago. But it became clear when Judge Easterbrook did not say anything for almost 17 minutes into the hearing, letting the state just ramble away, that it didn't appear that he knew if he had a friend on the court and he could bluster his way for everything. I don't know. We went in there expecting to lose. We walked out of there with hope that, that St. Eve was being reasonable and honest in her questions. She certainly was harder on her questions to the state than she was to our side, although I think she's still a bit confused about how to apply Heller, Bruin, and the like. But it was a very different hearing than what we saw 2 years ago.
Well, and if you could kind of delve a bit more into the characterization of the questions you heard from St. Eve, because she did have multiple tough questions to the state. How do you characterize those, comparing, what she gave to the state side, to Murphy, to even Dillon at the tail end from the DOJ?
Well, the state seemed to be grasping at some straws in trying to figure out a way to either get this case rolled back or, you heard them talk about error or erroneousness, de novo review, remanding it back because Judge Easterbrook thought they didn't answer a question. And there was first 10, 15 minutes was between Brennan and St. Eve going to the state because the state was just saying the lower court got it wrong. The lower court got it wrong. And hoping that if they said that often enough that it would just become magically true. And St. Eve was pressing them on the technicalities of those standards that, then aren't you having us do the fact finding and substituting our thoughts for what the trial court did in the trial and all that. So there's that whole part of it. And it was very, very different than the question, Erin Murphy, and kudos to Erin for the job she did standing up there. People will always Monday morning quarterback how certain attorneys do. And I will, on this case, if you're not the one standing up there getting peppered, having to argue, the standard of review, what, the rules are around erroneous findings by the lower court, not to mention all the technical nature of firearms and 4 Supreme Court decisions, It takes a little bit to do all that. And if you miss something here or there, I know that when I testified in front of committees, I would beat myself up. I forgot to say something. But here, the St. Eve came back to, our side and said, well, what about these mass shootings? And, she Aaron got there and did and just pushed back on it, just like and it was more of a touchy feely thing from St. Eve where I think a short answer is now you're back to interest balancing, and they did that earlier with the state's play where they were trying to ask some questions, and the state was, without saying it, asking for interest balancing all over, which has been verboten by the Supreme Court. So I'm heartened. I don't. Brennan's clearly on our side. He wrote a dissent against the last opinion. St. Eve replaced Wood, as you acknowledged earlier. So the question is, St. Eve has had a string of anti-gun rulings. What does she do in this one? Because she studied the record. There was a record. And Brennan made a lot about the record. So, and when Easterbrook tried to, well, they didn't do this, Aaron pushed back and said, hey, footnote 22, it's right there. It may not be in the format you like, but it's there. We put it into the record. We built the record. And I think that Judge Easterbrook's Hail Mary on a remand question because he didn't get it the way he wants it is just that. I think it's a Hail Mary to try to slow down what he doesn't see is that his view is prevailing overwhelmingly at this stage.
Todd, we've of course, have no idea when they're going to release their opinion. It could be weeks, could be months. It took them a good substantial amount of time to even just announce when they're going to be accepting briefs in the case in the appeals court, let alone setting the oral arguments date. But now that that's in the can here, how do we see this proceeding forward? Is it going to be a while before we get to a ruling on this and possibly up to the next steps to the U.S. Supreme Court?
That depends on a couple of things. One thing is that, the Seventh is quicker than a lot of other courts in terms of, turning out decisions. But it depends on which way it goes. The quickest way to the Supreme Court is for a 2-1 ruling against us. That puts us in control of the case, and we're in the driver's seat. We're the ones petitioning the court. And if that were to happen sooner rather than later, we don't like to lose, but in this instance, losing would be the fastest route to the Supreme Court. They could remand if Judge Easterbrook gets his hooks in the St. Eve and say, yeah, we want some more information, which will push us back down to the trial court and delay things. We could get a win, in which case I would wager that the state would seek an en banc review by the full court as to what the district court did and what this 3-judge panel came to a conclusion on. And then the question is, they have a certain amount of time for them to have the vote, which is usually about 2 weeks, and whether they take it. If they take it, that's going to drag it out longer. If they deny it, then the question is, will the state appeal this? Remember, when Madigan lost the Kerry case in 2013, that she did not appeal it to the Supreme Court. And the thinking is that we were the last state. If they took it to the Supreme Court and the court took the case, then they lost the country on the Kerry issue. Instead, we had to wait till 2022, almost another decade, to get the Bruin decision. So if they lose one here, I think they may not appeal it, that they would want to prolong things. They've lost Illinois. We're the only state in the Seventh Circuit that has a ban like this, and it would give them time to try to figure out what's going to happen with the other circuits. Those are just some of back of the napkin kind of.
Yeah,
I mean, you need a Ouija board, dude. You really do.
Some of the, yeah, or one of those whiteboards with, strings attached to everything. I kind of want to touch on something here just briefly with the questions that I heard primarily from Easterbrook was all about what the district court didn't do that Easterbrook said they told him to do. And Brennan really seeming to kind of counter that, saying this is a pretty strong record. It's the first district court case where we've had this type of record, 4-day bench trial, thousands of pages, and expert testimony from both sides. It's an uphill battle for the state, Brennan said.
Yeah, I agree, because Brennan gets the test. The test is, does the text cover the conduct? If the answer is yes, it is now the burden on the state to prove that the law or regulation they're trying to uphold has a consistency in history and is, found within the history of what we've been doing, and that the laws that they point to as analogous, the how and the why, are for the same purpose. And Brennan was not buying that from the state. He gets the test. He showed up. He was not this vocal 2 years ago. He was very vocal yesterday, and it was a welcome sight. It felt like I was in a different courtroom.
Todd, finally here, I know it's hard to prognosticate what you think the outcome is. What do you think is going to happen with this case? Which way is this going to go? What's your gut feeling?
I don't know. I was with a couple of the lawyers that dealt with this. I was with some other guys that have been involved in the case, and we all kind of came to the conclusion that it's 50-50 on a crapshoot, and it all centers around, what does St. Eve do? Do we get a remand because they want a little more and Easterbrook convinces her to do that? Do we get a split decision? ARs are protected, magazines not so. That puts us into a whole nother quandary about how to appeal that kind of stuff. And we don't know if the court is going to sit on this, waiting to see what happens with Duncan or one of the other cases that's pending at the Supreme Court. So, this thing is just, but we all get the feeling that this is the case the Supreme Court wants because of the record that was built. And remember, Thomas took a shot at them and said, if the Seventh Circuit is going to ban the most popular rifle in the country, then it's our duty to take this up. So whether or not St. Eve, I was involved in a amici brief for the Second Amendment Defense and Education Coalition, to where we took all the prior statements from the Supreme Court justices and put it down to say they've pretty much telegraphed what we think is going to happen, and you people should be listening to this. So whether or not that makes an impression or not, I don't know, but we certainly tried to get the arguments in front of them.
Todd, finally here, if you could encapsulate what you're hearing from your fellow gun rights advocates and fellow gun owners. You're the president of the Aurora Sportsman's Club. I was at the zombie shoot this year. Hundreds of people out there shooting all kinds of different firearms, from muzzle loaders to cowboy guns to even artillery, launching cannonballs 500 feet into the air, it looked like. What do you think the message from gun owners in Illinois is to this law and to the Democrats who keep pushing this?
I think the lion's share of gun owners are flipping the middle finger to the governor and the legislature about what they did. And they've pushed a lot of gun owners to a point to where they no longer care what the legislature has to say. They've just enveloped that much contempt for the conduct they're conducting in trampling our rights. With that, gun owners, they're cautious, they're quiet. You don't see some people putting as many videos or photographs or stuff in social media, but, for the most part, this is an annoyance. They believe it's wrong. It is a pain in the ass to deal with in certain ways, but we're out at the club. We're knocking on 3,000 members. We've got a membership drive going on. People are signing up. So They haven't scared away the gun owners, and if anything, they've just, made them dig their heels in harder.
Todd, we'll obviously be talking more about this in the weeks and possibly months to come to see what the outcome's going to be in the case challenging Illinois' gun and magazine ban. But I always do appreciate you being able to take the time with us when we can do it live. So we'll obviously talk again very soon. All right.
Take care.
It is Illinois in Focus Daily. I'm Greg Bishop with you each and every weekday morning here with the Center Square. You can find the podcast where you get podcasts. Go to thecentersquare.com for headlines. Get those free in your inbox at thecentersquare.com. Just click newsletter, sign up for it, and you'll get the headlines. But again, we go live here with Illinois in Focus Daily on the Center Square's YouTube page each and every weekday morning at about 8 o'clock. Tons of people tuning in this morning. It was great to see that. And obviously, there's a lot of interest in the gun and magazine ban challenge. So we'll continue to cover that for you here with Illinois in Focus Daily. All right, that's all I got for you today. Just 2 segments focused on the gun ban hearing. A lot of people have been waiting for this, so I was sure to try to get as much of the highlights as possible from the hearing. A long segment there, but definitely wanted to get you some reaction, at least from the gun rights advocates. Todd Vandermeide being one of those voices. So it is right here each and every weekday morning. Wake up with me, all right? Grab your coffee or tune in, listen audio only if you've got the ability to. You can catch the podcast and so much more. But tons of stuff going on today. The governor's got 2 events. We'll see what he talks about in those Q&As. We'll see what's going on in Chicago, and the Trump administration's got some stuff planned. So there's going to be a lot for us to talk about tomorrow. So wake up with us here with Illinois in Focus Daily each and every weekday morning, only with the Center Square.